Any bigger? No, I can't. The pen gonna work? It's running real light. Here we go. Watch your mic and set your mic down a little bit. There you go. You got it. There we go. Good morning, RRR Radio, 8:25 in the morning. R. Kelly, Step in the Name of Love. Good morning, Friday morning. Freeform Friday it is, but today's going to be half a show of Freeform Friday. The other half, attorney Raul Perales is in the casa, and he's here to answer questions. You've got any legal questions, you need any kind of legal advice, you know, right around that area, whatever the case may be, he's here for you right now. How much more better can it get than this? You're in the comfort of your home, your office, your car, whatever the case may be. You don't got to go to his office. He's here for you, and he's here to answer your questions. There we go. Good morning, shout out to Cristina Garza. Good morning, Irvi Ornelas. Good morning, America Munoz. Buenos dias, buenos dias, buenos dias. Anyway, good morning, Raul.
Good morning, Robert. Good morning, Robert Rivas Radio listeners. Glad to be here.
There we go. How we doing, Raul?
We're doing wonderful. Looking forward to helping some people out with their legal issues and getting ready to get started here.
There we go. It's you know, Raul, it's nothing like having Friday in front of us, right? The weekend in front of us. And what do? I get you in here, man. It's I got the day off, Robert. No, Raul, I need you to come in here, man. We got some people that need some help, dude. And you right. Show up, and I greatly appreciate it.
I'm happy to be here. I'm looking forward to this. I know there's a lot of people that have contacted you already with some issues, and I want to get into them so we can help some people out.
That's right. Okay, I tell you what. Right now, we're going to go ahead and attack as the one question that's been emailed. I'm not going to give the name, but I'm going to go ahead and give you the question that he is asking, and from there, you can take it and answer and give whatever kind of advice you can do. Now, here's the deal. This person says, I have a complicated question. I believe so. Here's my situation. The person says, I was involved in a horrible car accident back in 2016 and was hospitalized for weeks, was unable to walk for months. I was living in an apartment which I had just opened the lease about 3 months prior, and my attorney had hired my attorney I had hired for my personal injury case sent a letter to the apartment complex stating I would have to break my lease and move out due to my wheelchair not being able to fill through the doorways, and I was being taken care of 24/7 by my parents at their home. The apartment complex was very understanding and said they would close the lease free and clear. 1 year later, I have collections account on my credit totaling over $5,000 for my apartment. My attorney has since passed away. If you may have heard of him, his name was with the huge billboards. Who would that be? Any idea, though?
No, I don't know.
Obviously, the billboards weren't huge enough. So anyways, my new attorney has no say in the situation since he wasn't there at the time. Am I able to dispute this collection account, or am I screwed? Thanks in advance.
You know, you're always able to dispute these collections accounts. It's not... It's pretty frequent that things show up on your credit record that you shouldn't be liable for. Number one, we can contact the collecting agency and try to negotiate and see what their basis is for that. Obviously, it sounds like you are at the short end of the stick here because there was an agreement to go ahead and let you out of the contract, and presumably there's nothing in writing, but we can contact them and contest it. We do need more facts. My information is on the website, but we want to know the context of the conversation, who had the conversation, so we can contact, number one, the collection agency, and if not, then proceed to the legal maneuvers to get that removed from the record. But it can be done. There is a solution. We just need a little bit more facts.
So let me ask you this. In the apartment leasing business, the apartments, of course, they're looking out for number one, which is themselves.
Sure. That's the manager's job.
There you go. But on the other side, the leasees, the people moving in, they have their rights as well.
And the big thing that I noticed in this email is there was a difficulty entering the apartment complex because of the wheelchair. And I think that's a primary issue to take up, because if they can't accommodate that person, then they can't fulfill their end of the lease as well. So we can get this issue cleared up. It's just a matter of getting more information, more details.
I have seen too many headaches here. I'm not going to mention any names on some of the people that own some of the units where I live at, because these are condos, townhomes, and it's unfortunate that half of the condos here now, the owners, they flipped them over, and now instead of living here, they're leasing them out.
Sure.
Okay, so be it. That is what it is. But where do people who are renting draw a line and say, okay, my hot water's not working, my AC is not working? I mean, where is it enough to where they can... I mean, where is a judge going to side on the leasee side instead of the owner's side?
It should be on the leasee's side. If your owner, if your landlord's not doing his duty to uphold under the contract to maintain your property, then you have a right to break the lease. You should seek legal advice before doing that, or be really sure that you're doing the right thing. But absolutely, the contract is there to protect the lessee as well. And people don't recognize that fact. They think it's a tool to be used only against them. As a matter of fact, the apartment complex, the management company, they're the ones that prepare the contract. And so under the law, the contract should be construed against them if there's some ambiguity. And it should protect the lessee. But a lot of people don't have the time, don't have the money, or scared. And some people are just not too keen on facing authority. And they say, well, we'll just live with it, or we'll live with the blemish on our credit record. It'll be gone in 7 years. There really is ways to protect the lessee under the contract. You just have to contact somebody who knows what they're doing.
Out of curiosity, what is the time frame? Let's just say a person doesn't pay their lease for the month of October. Where is the time frame where the landowner, the person renting, how many weeks does it take for him to go, okay, now I can go to court and I got to get rid of this guy?
It really depends on the contract. Typically, your contract is going to say, hey, if you're behind so much time, we can proceed with eviction proceedings. So it just depends on the contract. It's a case-by-case basis. There is no fine line that says 15 days, 30 days. Depends on the contract.
And everybody's got their own little contract. And of course, and the contracts that they produce, of course, they're looking out to protect themselves in every angle they can, right?
And part of that protection is if you've already got a renter in there, you usually want to keep them, because then you have to go through the expense of getting the premises ready again. You've got to look for another renter. So they're typically willing to work with you, but they don't have to.
And that's unfortunate. Anyways, I tell you what, if you have a question for attorney Raul Perales, you can email me at robertrivasradio@gmail.com. And of course, también, if you want to just go ahead, I'm live on Facebook right now. You can put your question right here. We're good to go as well. And everybody listening as well, you can send me an email at robertrivasradio@gmail.com. Good morning, shout out to Christina Garza. Good morning, good morning. DJ Edward Castillo says, good morning, guys. There we go. Cynthia Gonzalez Ramirez, Maria Lopez, good morning, good morning. Yvette Charo, good morning, good morning. America Muniz, buenos dias. Janie Narvaez, good morning. Irving Ornelas, good morning. Now, I tell you what, Raul, let's get with another question here. Here we go. I'm not going to mention names, but I'm going to go ahead. Here we go. Another question. Attorney Perales, how do you get a copy of a will when you don't know the name of the lawyer who wrote it up and there's no record of it at the courthouse? I lost my copy. You're smiling.
That's unfortunate. That you may not be able to. If your attorney didn't keep a copy and you don't have a copy yourself, the only other thing is whether it was recorded at the courthouse. It looks like you've looked into that already. And so you're not going to be able to get a copy. Recording a will is something that's it's not mandatory. When you get your will drawn up, I always advise my clients that we should record it, because they are very often misplaced. I give my clients several original copies, one for themselves and one for the executor and one for the alternate executor. I ask them to put them away in different places in case one gets lost. We can always find one. But we always ask that they record them at the courthouse. Of course, it's not mandatory, because you can change your will at any time, as many times as you want. The will doesn't take effect until you pass away. So if you didn't have another copy and your attorney didn't have another copy, you need to make another will, because there is not going to be some place where they've registered it if it wasn't registered at the courthouse.
Does the will ever take into effect if the person is not in a state of mind anymore. He's not.
When you prepare a will, typically you're going to have it witnessed. You should have it witnessed, and there's two separate things that the witnesses are signing the will for. Number one is an attestation clause, and number two is a self-proving affidavit. Basically, what the witnesses are doing is they're signing the will after having witnessed the testator sign the will, the person whose will it is, and they're attesting to the fact that the person is of sound mind and body and knows how they're disposing of their estate. Unfortunately, I've had some people come to my office with a person who's not mentally there. And so I have to explain to those people that sometimes the time for preparing a will that's passed because the person doesn't know what they're doing. You know, the person may have dementia or just not understand what they're doing. So, yes, you have to be of sound mind and a body to...
So pretty much, in the case of this person here, you would say...
Yeah, I mean, it sounds like you're not going to find a copy, and I would advise you, I would urge you to go see an attorney about making a new will. It can be the exact same terms, but you need one. Because at this point, if you were to pass and that will isn't found, then your will isn't going to take effect. Your property is going to pass through the statutes of descent and distribution, meaning your heirs will be identified, and the property will pass to them at the certain percentages attributed by law. So you're not going to get to say who gets what.
I tell you what, everybody, of course, Attorney Raul Perales is joining me live on my morning show, and it's not too late to email me your question. Is to go ahead and just email it to me at robertrivasradio@gmail.com. If you're joining me live on Facebook, you can post your question here right now, and he will be, I tell you what, Yvette Charo is asking, Attorney Perales, can the will be in writing and be legit?
Yeah, there's no specific requirements for a will. You have it just has to express your present intent. So in other words, it has to say, my desire is that my property, when I pass, go to this person. Okay, it's better to have witnesses. Okay, because then they can, when they sign the attestation clause, they're attesting to the fact that you're of sound mind. When they sign the self-proving affidavit, then the witnesses don't have to appear in court to testify that they were there and they saw you sign the will. But a will can be written on a napkin, and as a matter of fact, there's a very famous case. I believe it was out of the St. Anthony Hotel. Before the gentleman jumped out the window, wrote on a napkin, "This is my will, and this is what I wanted to. This is how I want my property disposed of when I die." And the court ruled that that was a valid will. But you're running the risk, if it's contested, if it's not witnessed there's not an attestation clause, a self-proving. So. Best practice, go see someone who knows what they're doing. Because it sure would be a shame if you think you've taken care of that and it hasn't been taken care of. I've had situations where I've got one particular case right now. It's a very complicated case. I'll share some of the details, of course omitting some names, but I've got the family of a woman who was diagnosed with a terminal disease and was told she had a very short time to live, and her husband, upon hearing the news, committed suicide, and because they ended up dying within 3 or 4 days of each other, and because of that, and they died without wills, they are each presumed to have died before the other person, and so half of the estate is going to descend and distribute through her heirs, and half of it through his heirs, and it's an incredible mess.
Wow.
And you've got family with a lot of stress, probably looking at a lot of expenses, and it could have been avoided had there been a will. And people, I know people don't want to think about it, they don't want to go in and see an attorney, but it really does save a lot of heartbreak, and I've seen families torn apart.
Right, sure. Confusion and everything else. Good morning, shout out to Nancy Hernandez. There we go. Feliciano Gallegos. Good morning, Nancy Hernandez. Good morning, good morning, good morning. I tell you what, like I said, if you have a question, Attorney Perales is here right now to answer your questions, any kind of legal advice, whatever the case may be. He will answer your question, being is that you squeeze it in by our time frame. Anyways, if you got something going on, you know somebody who's got a question about a divorce, about any kind of a judgment, whatever the case, do not be shy. That's what we're here for right now. You can put it right now on Facebook, on live right now, or you can email me at robertrivasradio@gmail.com. Now, Mr. Perales, let me ask you this. I'm going to call you Raul because we're buddies.
Yeah.
Raul, that person that you said jumped off of a hotel room, but he wrote a will, could it be challenged that he wasn't as right mind to write a will, being that he's committing suicide?
Any person can challenge a will. You know, if you have standing, somebody could have challenged it under that premise. They didn't. They just challenged the validity of the will because it was written. But certainly that's an argument that could have been posed. But the burden is on you. If you're claiming that person isn't of sound mind, then it's your burden to show the court that they didn't have the capacity to understand what they were doing with their property. And
you know, I have seen funny stories, Raul. I have seen funny stories where a lady or a man, they leave their millions of dollars to a dog or a cat. And I take it it's possible to do that, right? To leave it to a dog or a cat, or
you can leave it. Yeah, sure. You can do whatever you want. It's your property, and that's what it is. This is my will. This is what I want to happen with my property. Typically, you'll establish a trust or something because obviously a cat or a dog is not going to know what to do with the money.
Give him a debit card, man.
But I can establish a trust where Robert Rivas is going to decide how to use this money on behalf of the cat, the dog, or the niece. It doesn't have to be a pet.
I tell you what, let's get to another question here. Any questions, like I said, any questions whatsoever, the questions are coming in through my email at robertrivasradio@gmail.com. This is your time, people. You need some legal advice. This is your time. Attorney Raul Perales is here to help you with any kind of legal question. This is the time right now. You can put it right here on Facebook Live, or you can send me an email at robertrivasradio@gmail.com, and everything. I will not announce your name. That I do promise. There we go. Another question. We're going back to the wills here. A will, like when you die, and what do you need when you make a will? I want to know the cost of a simple will.
The cost is really a function of exactly what's going to happen. When people refer to a simple will, they're typically saying, you give your identifying information and you're saying my property is going to this person, and then the residue of my estate is going to that person. It really depends, but for a simple will, you're probably going to spend under $500. Okay, that's for the preparation of the will. What do you need? You just need to make an appointment and come in and see me, and we'll talk about what you want. Typically, we're going to get your information, which you should have on hand: name, date of birth, whether you're married, the names of your heirs, children, whatnot, and then discuss what you want to do with your property and the best way to do it. One of the issues that comes up a lot is, I don't want to give my home to this person, but I want him to stay there until he passes away, and then when he does, to my kids. So for instance, if you're not married, you've got a home, you're living with somebody, and you'd like for your life mate to stay in the home, but you don't want to give it to him because when he passes, you want the property to go to your children. That's called the life estate. So it's just a matter of sitting down and talking to you. Typically, for a simple will, you don't need anything else.
But the more property, the more money, the more complicated.
Oh yeah, absolutely, absolutely. The cost is a function of what needs to be done. Okay, and how much work it's going to take. And the only way to adequately give you a correct answer on your particular case is to have you cross my desk so we can discuss what the issues are.
Good morning, Shada Ganata. Elda Garcia también, Jerry Wadia. Good morning. Yvette Charles says thank you, Mr. Perales. There we go. Now, I've got a question for you. It seems that every day in the news, man, you see where a guy's trying to kill a woman or a woman trying to kill a guy, and they have these, what is it called, that piece, where they got to stay a
restraining order,
protective order. Now, I'm going to go on the girl side here. Now, let's say a woman is trying to get a protective order against a guy. This guy is harassing her, and man, she's got to get a protective order, man, a restraining order, but they have no money to protect themselves.
Couple of different things you can do. Number one, you can go to the district attorney's office, and they can help you with a protective order. Protective orders and restraining orders are different things. Protective order is more comprehensive and really in a situation where life and limb is at stake, a protective order is what you want to seek. And that's, so in situations where there's been an assault or things of that nature, the DA has a section, the district attorney has a section that only works with people that are coming and seeking protective orders. And what they have to show is that person is reasonably in fear for their life or their safety.
And they got to prove that.
They don't have to prove it, but I mean the facts have to be there. Okay, so the DA is not going to take your case if there really isn't a serious issue.
Of course, somebody can make it up
Yeah.
and just say, "I want this guy away from me."
Yeah.
So you want to separate the real ones from
I mean,
the fake ones.
we're talking about the fact scenario where you're riding in a car and he opens the door and tries to push you out, or
Right.
things of that nature. A private attorney can also help you with a protective order. If money's an issue, you're probably going to go with the DA. Typically, that tends to take a little bit longer, and they don't take every case. Just because they don't take your case doesn't mean you're not entitled to a protective order. Judges are very honed in on these situations. They want to make sure people are safe, especially when you're dealing with an individual who's acting unreasonably, who's making threats, who's scary. So you can come in and see an attorney, and the protective order filing fee is very low.
Actually, see you.
Yeah, exactly. So it's a, and then you can always seek attorney's fees from the perpetrator. You can ask the judge to assess attorney's fees against that person, and that helps defray the cost as well. So a restraining orders is not as comprehensive as a protective order. In Bexar County, as of about 3 or 4 years ago, anytime you file a family case, there's a standing restraining order that automatically gets attached to these divorces or suits affecting parent-child relationship, paternity suits, and that stops people from doing things ordinarily they can do, withdrawing a child from school, leaving San Antonio, and basically what the restraining order says is, while this lawsuit is pending, you're not going to do any of these things, and it applies to both parties. So there's a lot of again, they're very fact intensive, but we can help with that.
So let me ask you this question. Would you say it's fair to say that in the family courts there's a high percentage of these domestic quarrels going on in there about protective orders and stuff like that? Is
There's a good number, but I wouldn't say the majority of the cases deal with violence, but a lot do.
So a lot's going on, domestic abuse, violence, whatever the case may be.
People go through a divorce, they become unreasonable, they become uncommunicative, they're not communicating, so a lot of difficulties arise, and that's precisely why the judges in Bexar County very wisely 4 or 5 years ago decided to build in a standing restraining order with all these cases, because these issues were coming up. One of the issues that I see a whole lot, I mean, I'm talking about 2 or 3 times a week, somebody comes in to see me with this issue. We're not married. My wife or my significant other left and took the kids, and now they won't let me see the children. Mm-hmm. And that's a difficult thing. They're hiding the kids, and that restraining order helps with that situation. But it's something you need to get into court so you can get an order, so the ground rules can be laid, so that someone's not using those children as pawns.
Now, I'm going to remind everybody, I am talking to attorney Raul Perales, and of course you can always get a hold of him at area code 210-212-5592. I'm going to say it again. Attorney Raul Perales, any kind of questions, whatever, you can always call him as well at area code 210-212-5592. His offices are located right there by San Antonio College here in San Antonio at 201 West Popular, and this man has been practicing law since 1999. Now, just because he is located here in San Antonio does not mean that he cannot help you in other parts of Southern Texas, regardless of where you're at. Give the man a call, and he can take care of you. He really, really can. Now, that being said, Raul, let's get back to another question here. Let's see here. I'm trying to... Okay, let me see here. I got with that one. Let's get with this one here. Another question. Person says, my mother has always wanted me to be her decision maker. When it came time when she is unable to, where do I get started? And would I need an attorney? Can this be done by a notary public, for example?
What you need is a power of attorney, and there's many different types. There's a general power of attorney. There are things called physician's directives. You should see an attorney. You should see an attorney. These issues are too significant to not get right. The only thing that a notary does, the only job that a notary has, is to verify that the person signing the document is the person who they claim to be. Okay? They don't have any special skills or training in preparing documents. I understand that there's a lot of people that work with powers of attorney, but I've seen situations where powers of attorney have been created, and then the person who gave the powers becomes incapacitated, and because the wording was incorrect on the power of attorney, then the person they designated couldn't make certain significant decisions. So they basically had a piece of paper that was worthless. And again, the reason this is important, because our loved ones, whether we like it or not, at some point are going to get ill. They may be unable to write checks, to cash checks, to fulfill contract obligations, to make medical decisions on their own. And it should be a loved one being able to make those decisions for them, to facilitate difficult situations. This is something that I would strongly advise when you're considering these decisions that are going to impact you. You've got to go in and see an attorney. You've got to. It's too important to take shortcuts.
You need to see Raul Perales. That's who you need to see now. Even more so, Raul. Does it get more complicated the more siblings that are in that family that may challenge? They may challenge what's being said here, saying, "Well, maybe mom doesn't know what she's talking about. She wants me to do it."
The situation that comes up a lot is where one or a couple of siblings have taken on the primary responsibility of caring for an elderly parent, and then that person responsibly and reasonably goes to see an attorney and says, "Hey, look, I need a power of attorney because I know mom or dad is getting to the point where they may not be able to make decisions. So they've got a social security check coming in, but they've got bills to pay." Excuse me. And so they rightfully seek a power of attorney. Unfortunately, a lot of the times the other siblings look at this as, "Oh, look at that. They're starting to dip into mom and dad's money. She's not even gone yet. He's not even gone yet." So, I mean, unfortunately, a lot of families have their black sheep. Unfortunately, people are distrusting. But you're really caring for the person. You've got to make the correct decision, and hopefully that doesn't happen. But if it happens,
and I promise you, you've seen a lot of ugliness.
Oh, yeah,
in all this.
Absolutely. That's why I advise my clients: make your wills, get your power of attorneys done when you're healthy. When you know what you want, when you're not under stress, when you're not under pressure, make the decision then, and then let your kids know, "Hey, I've already made my will. You guys don't have to worry about it. It's not in your hands." Because once the person dies, there's so many issues that the family's dealing with, so much grief. And then if you add on top of that, "Hey, who's going to get the house? What are we going to do with the house?" All of a sudden people say and do things that they can't take back. And I've seen fissures created in families that are never repaired over something that could have been avoided, completely avoided.
Sure. That's where confusion and all that comes in, and then before you know it, man, they're at each other, and and all over a house or over some money, and you have no more relationship, right?
Absolutely.
No doubt. I'm here with attorney Raul Perales, and of course, you are on RRR Radio Morning Show. I want to thank everybody for joining us. It is not too late. Mr. Perales is going to be here for a while longer to answer your questions. Don't be shy. Send me an email at robertrivasradio@gmail.com. I will not put your name on there, and he will answer your legal question, any kind of legal question you have. He's here to answer it for you. Good morning, shout out to Ara Cantu. Good morning, Anthony Hernandez. Buenos dias. Rosemary Flores. Good morning, good morning, good morning. Liz Vega Caballero. Good morning. There we go. Jeffrey Wadilla. Good morning, good morning, good morning. I'll tell you what, we're going to take a break in the action, and we'll be back here in just a little bit. Good morning, RRR Radio. Freeform Friday, and right now here with attorney Raul Perales. We'll be back here in just a couple of minutes. How we doing, everybody? We're going to take a break here. We're going to go back live here. Get your question ready. Whatever you may have, get it ready. And this man will answer it for you, okay? Good morning, Prima. We'll be back in about 5, 6, 7 minutes. We'll be back.